Properties Act came into effect in 2020 with the aim of subdividing buildings into units that were individually owned. Today, we are demystifying what the Sectional Property Act is all about, and we're here with James Gitau, an advocate with Simba and Simba Advocates. Welcome to the Property Simplified show. I am your host, Claire Munde. Welcome.
Thank you.
Now, to start with, tell us what exactly is a sectional unit?
Now, a sectional unit is basically one unit. I'll make it this simple. If you go to a house, say a flat, and you have different houses, house number 1, 2, 3, 4, A, B, C, in whatever form you choose to name the houses, the house number 1 or A, that particular house is a sectional unit. It's a unit of the entire building, so to say. And that is what the Sectional Properties Act comes in to give individual ownership or title that can be used by the proprietor either to sell, charge the property, or transact in a way that they deem fit. So it's an isolation of the entire block or apartment, that one particular house that you own as an owner of an apartment in a unit.
Okay, so an apartment would fall under this category, a maisonette,
yes,
an office. Yes. What other kind of unit would fall under that?
You'd have also townhouses. Basically, when you look at, for example, an office, you'll have a particular floor that would count as a unit of this particular property, or you'll have offices where people have subdivided and they decide to sell the space. So that particular space has to be defined, and that's what would fall under that category. Definition would be by the floor, walls, ceilings, windows, so that when you look at a description of this property, from where you're seated, you should have sort of a picture of what it looks like. And that's what really, so the main units would be houses, townhouses, maisonettes. You'd have apartments or sections of apartments, and commercial offices, office spaces rather.
Okay. Now, there's been a lot of confusion about this act. There are people who bought the apartments, the townhouses a long time ago, and they're wondering, is my lease still valid? What do you have to say about that? What is the situation?
Yes. Now, the leases are still valid for those who are concerned, because the Act as it is provides for a measure of, or a means of converting that lease from the long-term lease into a sectional title. The lease that you'd have, that long-term lease, was one where these interests would be registered against the main title. Because ordinarily, under conventional land laws, you don't have multiple titles being issued on one piece of property. It's just one. And that one title, once issued, so long as you bought a long-term lease, that interest would be registered against the title. That's what you have as a lease, a long-term lease. It looks like a document in the form of an agreement. That's what we've used for the longest time, much as we had even before the coming into effect of the Sectional Properties Act. We still had a Sectional Properties Act of 1987, but practice, or people in practice, seem to prefer owning leases or having registration of leases as opposed to sectional titles. So when you have those long-term leases, yes, they are currently valid. The process that is required is simply for you to go ahead and apply for conversion of the long-term lease into a sectional title. So having a long-term lease is not, with the coming into effect of the Act, is not a termination of the validity of your current lease. Those leases are perfectly valid as it is.
Okay, so tell me, what's the step-by-step process of converting this lease? And is it me who's responsible? Are the developers involved in any step of this process? What's the process like?
So the process is pretty much straightforward. You'll have those properties that the developer still holds the leasehold interests. And for those particular properties, it's the developer who is supposed to initiate the process. So if you have a developer who was selling 15 houses. They've sold about 10. 5 are left. They are still in control of the mother title to the property, and it's incumbent upon them to start that process. This would be initiated by visiting a surveyor. Number one, the professional, that's the first professional that you will need to contact. Their job is to draw up a sectional plan. Basically, a description of the units in that particular apartment, all of them. And once that plan is drawn up, you'll then proceed to register that sectional plan. You won't just submit that particular sectional plan alone. There is an organization or a corporation that's formed under the Act for management of this property. You'll submit the plan along with an application to incorporate this particular corporation. So the corporation is separate from companies, other companies as we know them, because other companies are governed by the Companies Act. They have their own regulations. This corporation is incorporated under the Sectional Properties Act. And once you submit the sectional plan along with the application, and the same is registered, this mother title, the one that the developer is in control of, is effectively closed, and new sectional titles can begin to be issued. So once the mother title is closed, then you with your long-term lease, you're expected to submit that lease document so that the government can in turn process and issue you a sectional title. That's for properties that the developer is in control of. Now there are those properties where the developer sold all the units. You have 15 units, the developer sold all 15 units and had incorporated a management company to manage these properties. Now, what most developers do or are expected to do is upon sale of the last unit, they're supposed to change reversionary interest to the management company. Now, what we mean by reversionary interest is you'll have a lease for 99 years. At the lapse of that 99 years, you may elect to renew the lease or you may elect not to renew the lease. If you're a homeowner, it's in your interest to elect to renew the lease. Now, the lessor is the government, that's a person leasing, and the lessee is the developer. The developer ordinarily, as the lessee, has the power to apply for renewal. However, once they transfer reversionary interest to the management company, then the management company becomes the organization that has the ability to apply for renewal. And that ability to apply for renewal is what we are looking at when we talk of reversionary interest. Now, once that is done, you will have the management company having the ability to renew the lease. But that was just to give us a good view of what is reversionary interest. Back to the conversation, once the management, if the management company is the organization that is currently in place and has reversionary interest, that is the ability to renew the lease, it is essentially the lessee, then the homeowners through the management company may commence the process of conversion or converting their old titles into new titles. The process is pretty much the same as where the developer holds the leasehold interest or the mother title. They'll need to approach a surveyor to prepare the sectional plan. They'll need to incorporate a corporation under the sectional properties and make that application. Now, there are certain modalities that homeowners may want to look into, such as this corporation, once it's established, it has to have bylaws. Those bylaws are the rules that govern how things are done or how you interact with your property, your neighbors, those who you share a common space with. So those are the bylaws are what will tell us, for example, how do you maintain the common area? Should there be insurance for the common area? Should I come and visit you when you live in a property that is now converted into a sectional property and I happen to get injured? Legally, I'm entitled to sue and recover. Now, the person who is in charge of that particular property is the one who will be suing or be suing in order to recover from my injuries. Now, you can't sue 10 people or 15 people. It would be cumbersome, expensive. it would be a nightmare. The management company, or sorry, the corporation rather, is the organization that is in charge of taking up liability, defending if there is a defense that needs to be mounted. So the corporation guidelines or bylaws would be able to help you maneuver through all these nitty-gritties. Once you've registered the corporation, then you have a title. So those are the methods of converting when the developer is in control, and number two, when the management company has taken control. So yes, these titles are valid and can be converted. That's just a breakdown of the steps that you'd need to go through. Of interest too is you'll have properties that are charged. I bought an apartment on a loan and the bank took that title as a collateral. So for these particular individuals, it's important for them to liaise with the bank, because the bank holds the leasehold interests, or the lease, instrument as a collateral. You don't have anything, yet the house, for all intent and purpose, is yours. You're merely servicing the loan. So it's upon the proprietor of the unit to make the application for conversion, and once they've made the application, they'll either submit it to the bank or have a discussion with the bank's advocates and their advocates as to how the collateral that is held by the bank would need to be submitted at the lands office for conversion into a sectional title. Of course, that moves with the interest that the bank has, so that you don't just get a title that's free, yet the one that you gave had an encumbrance, or it had an interest in the form of a charge that belonged to the bank. Okay. So that interest would transfer.
Okay. Yes. Okay. Now you've talked about conversion when the developer is in control. Let's go back a bit on that. There have been instances where apartment owners have complained that even getting share certificates is a problem. So what do you do when a developer is in control but they seem to be derailing the process? Because there are instances where units are sold and some apartment owners complain that all units have been sold, but then the developer is just dragging the process out. So how does one deal in that situation?
So the Act has envisaged such a scenario. I think part of what the Act was trying to cure is a scenario where the developer retains the reversionary interest perpetually, which could be problematic if, say, the directors of the company that is the developer part ways and the company is just left as a shell, or if you have the company collapsing, you have a lot of problems because the developer had or has to have a hand in your conversion process. The cure that the Act provides is that this process of conversion can be initiated either by the developer or the homeowners. It's not a reserve, strictly speaking, of the developer to initiate the process. The developer initiating the process would merely serve to have some convenience, sort of. So you don't have 10 homeowners running to the lands registry and each wants to register their land. You may end up having some conflict. So the developer initiating, that's purely for convenience. Otherwise, the proprietor is allowed to initiate the process, and that's a primary person who is supposed to initiate that process. If you have a bank that holds titles, then the bank can push to instigate that process so as to ensure that there is conversion. So it's not just a sole preserve of the developer. The proprietor has that primary obligation to ensure that they convert their units into sectional units.
Okay, and then let's talk more about common areas. In this regime of sectional titles, how does it work? How are the common areas owned? What happens there?
Okay, so I'll make a scenario where you have, say, a gated community with common area, with a road that leads to your house, that's part of the common area. You'll have the pavement, you'll have gardens that are well manicured. That's part of the common area. Now, you will note that under the Sectional Properties Act, all the owners of these various homes have a share in that common area. Now, if it's 10 people who own the homes, for argument's sake, you will have each one of them owning 1 out of 10 of the common area. Now, you'll note, for example, the person who's just next to the gate. They can't come and say, my common area is this one next to the gate, and for you to get in, you need my permission. No, they own this property as tenants in common. What that means is, it is possible to ascertain what share of the common area you own. However, you are not ideally to sort of divide or take your area absent from the rest of the area. If you have, for example, flats and you have stairs, those stairs would form part of the common area. If someone on the second floor decides, now these stairs are mine, you can't access, now that's not acceptable. You will have the corporation coming into effect or coming into place once you've registered it, that will form bylaws. Those bylaws will govern how you deal with that common area. Issues of maintenance, you'll have street lights, who pays for that electricity, you'll have people who come and water, who pays for that. You will have, for example, if liability was to occur on that common area, what happens if there is insurance that's needed? Now the corporation comes in to manage that common area on behalf of every single homeowner, and all the homeowners are essentially part or have an interest in the corporation. So that's how we deal with the issue of the common area and ensuring that at the end of the day, each and every homeowner's interest is protected. And number two, each and every homeowner has a share in the common area. Finally, I think I'd want to note that the ownership in the common area is proportionate, so that if you have one house, you have one share in the common area. Someone with 2-3 houses, each house would carry its own share in the common area. So yeah, that's pretty much how we look at or how we deal with the common area when you have different homeowners.
Okay. And then now for people who are buying units right now, is it being done under the Sectional Properties Act, or is it now still the former regime? How is it going?
That's an interesting question. Now, you'll know the Ministry of Lands, as of last year, May, had issued a circular or public notice to the effect that they will no longer take up long-term leases for purposes of registration as a means of transferring property from one individual to another. However, after engagements with the Law Society of Kenya, there was a notification, mostly to lawyers who are in conveyance practice, to the effect that the Ministry of Lands, having considered certain factors, for example, at the time, you didn't have regulations to the Act. Now, regulations to the Act are what gives the Act the ability to operate. You'll have the Act as more of a skeleton. The regulations fill in the gaps to make it something that can move and something that's alive. At the time the circular was being issued, the regulations had not yet been passed. That was in May. The regulations came into effect in December of 2021. So initially the ministry had indicated they won't accept any new long-term leases, but after engagements, that position seems to have been changed. However, you'll note that the Ministry of Lands, if you check through their website, the only notice you will find on sectional properties is the one indicating that the ministry will not accept. So there is a gap in terms of what's supposed to be done, but practically, if you go to lands office or any lands registry, you will find that those who are registering, they continue to receive leases under the long-term leases. However, new developers, those who are starting off, or those who started off with development after the Sectional Properties Act, the expectation is that they will register these units under the Sectional Properties Act. See, the ones who are continuing to register, there is still a process for them. They're supposed to, at the end of the day, apply for conversion. So if you're a new developer, the expectation is that you will register under the Sectional Properties Act so that you avoid to having to go through the conversion process, given how long at times processing of titles may take in our registry. So the expectation is new developers should be registering under the Sectional Properties Act.
Okay, and you're talking about duration. About how long does it take to have this conversion happen? So I have my lease, my long-term lease agreement. What's the timeline of getting it converted?
Now, the timelines may vary from one scenario to the other because they are affected by several factors. For example, you'll need to approach a surveyor for them to prepare a sectional plan. So there's the time period that a surveyor would take to prepare a sectional plan. Number two, you'll need to visit an advocate who will then prepare or assist in preparation of the corporation bylaws, who will need to assist in preparation of the application for registration of the corporation. And once you have these two, you are expected to submit these documents at the lands office. So as it is currently, we'll note that the regulations came into effect in December of 2021. So in terms of the practical application, we are 6 months in. To give a definite timeline might be somewhat of a challenge because of how relatively new it is. You may have a bit of teething problems right from the professionals to the lands office, the people who are doing it practically. So at the moment, I think it would be too soon to give a definite timeline, but those are the factors that you look at. Other than the advocate, you'll then look at the registry. There are processes that go on in the registry. You don't just submit your documents and someone sits and types out a new title for you. I'm sure the registry has to do their own due diligence and have their own expectations as to what to look out for before they approve that particular conversion. So you have to factor in that there is some period of time that the registry will need to take before you end up having a sectional title. So as it is right now, those are the factors that affect the timeline, but because of how relatively new this application of this act is, it's then difficult to point to a specific timeline. Probably going forward, and once we have accustomed to the Sectional Properties Act, it would probably then be possible to give realistic timelines of what to expect. Of course, at the end of the day, it's expected that this process will be done efficiently so that you don't have someone telling you that you will wait for several years. The expectation is this should be done within a reasonable amount of time.
Okay. And then land transactions have gone digital with the Artisasa platform. So for this conversion, is it also being done on the Artisasa platform, or what's the situation? And you can also just describe the Artisasa platform for those who may not be very familiar with it.
Okay. So the Sectional Properties Act, once it came into effect, from a reading of the government and the expectation from the CS, it's that this conversion into sectional properties would be done on the Artisasa platform. Now, Artisasa, since it was launched, only covers properties that are within Nairobi County. Now, that's strictly speaking what is Nairobi County. So properties that you buy in Nairobi, you'll be expected to convert them into sectional properties or have them sold to you as sectional units, and this is done on the Artisasa platform. Now, the Artisasa platform is a digital platform that enables you to transact in property. So when you get into the Artisasa platform, there are different players. You will have the advocate representing the developer, you will have the developer, you will have the buyer of a unit, and possibly the advocate representing the buyer of the unit. Now, applications on the Artisasa system are mostly instigated by the advocate, so that if I need to conduct due diligence, my advocate would come in, log on to the website, go in and click the search tab. There are different services that are provided for. So once you get to the home bar, your home screen, you'll see the services from conducting search, charging property, transferring, and so on and so forth. So the advocate initiates the search and applies for the search, describes the property, and gives a brief narration of what it is they are looking for in this property. Is it the proprietorship details? Is it the encumbrance sections? That is, are there any interests on this property that would restrict its sale, transfer, or any transactions? And then the advocate is expected to submit the application. Once they submit the application, you, the proprietor, are expected to have your own Adisasa account. Now, when you have your Adisasa account, it is expected also that you will upload the titles that you own for Ministry of Lands to verify. If your property happens to be verified and I'm conducting a search, the platform will prompt you to either accept or decline my application for the search. Once you accept, then the process is complete from our end, and it's now up to Ministry of Lands to then issue a search. So you see, it's a system that involves the interaction of both advocates and homeowners, and advocates in the event that you intend to purchase, and the purchasers in the event you're a bank. The interaction is between the advocate and the bank. But at the end of the day, yeah, the cycle involves you having to approach an advocate, and this is a system that's there as a result of our laws. Our laws anticipate that conveyance transactions would necessitate for there to be an advocate due to, one, the intricacies of the law that may not be apparent to every other individual, and number two, because there is a standard that is expected of an advocate in terms of responsibility. You have a duty to your client to ensure that this property, when you're dealing with it, you are able to deal with it in a manner that they have a good title at the end of the day, or if you notice anything wrong with the title, you'll be able to advise on the title. So that's basically a brief description of the Adisasa system. So it is also anticipated that these applications for sectional properties would be done on the platform. I believe surveyors are able to also access the platform and make these applications, because you'll have the surveyor having a role in it, and then you'll have the advocate who will then make the application for registration of the corporation along with the sectional plan. So you will have these various players interacting with the platform, but at the end of the day, I think what I can credit the platform with is it gives the proprietor control, so that whenever I want to transact, for example, I have to seek the input of the proprietor, be it them accepting whatever application they are prompted to accept, or them signing off. So if you have a transfer and there is need for execution, there's a place or a particular spot for the homeowner, the proprietor, to sign off before I can then proceed to transact, or I can proceed to witness on whatever it is they're signing off on. So really that's a brief description of the Adisasa platform. Currently it, from what we've seen in practice, is operational within Nairobi. Outside of Nairobi, I think the ministry is yet to roll out. So yeah, we are still getting to terms with how the system works. But yes, within Nairobi, it's expected that you'll make your application on the Adisasa platform, and the whole process should be done within that particular platform.